Why do you think gym owners should do everything they can to avoid a negligence lawsuit?
Yeah, I think, when a negligence lawsuit is filed, first of all, somebody's been injured, okay? They have a lawyer. The lawyer files what's called a complaint with the court, and that initiates the lawsuit. And then after that, sometimes it takes 3, 4, 5 years before that case either goes to trial or is settled out of court. So it's a very long period of time, okay, first of all. So it's very time consuming over those several years and a very stressful time as well. So what happens once the complaint is filed? Shortly thereafter, there's what's called the discovery phase. And this is where all the evidence is collected, okay? So, for example, the plaintiff's lawyer might want the defendant, the gym owner or manager, to provide a lot of documents. So they might ask the court for the lawyer of the defendant to ask the defendant for these documents. They can be the waiver, release of liability. It could be a membership contract. It could be equipment maintenance records, injury reports. It could be all kinds of different documents that they're seeking, depending on, the injury and what happened and that kind of thing. So you might have to produce a lot of documents as the gym owner or manager. In one case, the defendants had to produce 750 pages of documents. So you can think about the time and the stress that can create. The other thing that happens in the discovery phase is the testimony that you have to provide under oath. So you're going to get questions from the plaintiff's lawyers, and you have to answer them under oath. And that can also be very stressful, okay? And you just don't want to put yourself in that situation. And so, from a time perspective, from a stress perspective, it takes a long time usually for these cases to finalize. And so it becomes a very, what I would think of as a very stressful period, because you don't know what the outcome is going to be. Are you going to be liable or are you not going to be liable, in a negligence lawsuit? And the other thing is, if the media covers the injury, and sometimes like a wrongful death case or a serious injury case, the media will cover the case. And, that can end up, having a negative effect on the club or the gym's, reputation and future business, really. And so you don't want that to happen either. So I think for a lot of reasons, from a time perspective and a stress perspective, you want to do everything you can to ever being named as a defendant, in a negligence lawsuit. And then also all the time that, you're spending with your lawyer that's defending you and going over a lot of the issues and everything with the case. So it's very time consuming. I would guess that most gym owners and managers would prefer to use their time differently, spend time helping their clients and their members become healthy and fit would be much more fun, enjoyable than dealing with, the lawsuit and then worrying about it for so long, for a long period of time. So I think that's, a major, reason or reasons, why you would want to try to avoid being named as a defendant in a negligence lawsuit.
Sure. Also, if you were thinking about selling the club, that's forget about that, because now it has to be disclosed, or that's its own source of trouble. So to best defense, to make sure you're not in a negligence lawsuit, like what are some things that everybody should be crossing their T's and dotting their I's with?
Yeah, well, I think your best defense, okay, and a lot of times, gym owners and managers might think, well, the only thing that would be a defense for them would be their waiver or their, liability, release of liability. And remember, that defense is only effective for you after the negligence lawsuit has been filed. Waivers or releases of liability do nothing to enhance safety. Okay, nothing whatsoever. So, when we talk about, preventing injuries, okay, in a gym or health club, we need to think about, definitely the safety of our environment, the safety, that our trainers and instructors are really thinking about safety all the time, of course, but also not to be breaching any duties. So in a negligence lawsuit, the plaintiff has to prove 4 elements in a negligence lawsuit. So they have the burden of proof, the injured party that's filing the lawsuit. So the very first thing they have to show is that there was some kind of duty, okay? Some kind of duty that the defendant, the instructor, the management, whoever the defendant might be, had some duty that was owed to that plaintiff, okay? And so we have in fitness facilities, we have a lot of duties. And I think one of the concerns is that people in our field, fitness managers and instructors and so on, might not realize what all of those potential duties might be, okay? And that's where the education comes in and reviewing case law so you can get a better understanding of how courts determine duty and how the plaintiffs have to prove that duty. So first you have to establish a duty, okay? And then the plaintiff has to show that there's some kind of breach of duty. So the defendant didn't carry out that duty properly. They breached that duty. And then the breach of duty was the cause of the harm or the injury. So those are the 4 elements: duty, breach of duty, causation, and then harm or injury. And then, of course, what the plaintiff in a negligence lawsuit, which comes under civil law, the plaintiff is seeking monetary damages. Okay, so you hear about these cases, a lot of times can be in the millions of dollars. There was a personal trainer case, $14.5 million. There was not too long ago a jogging class at a university where the student suffered a very severe heat injury, and that was settled for $39.5 million.
Can you go over that case real quick of like what happened? Do you know the particulars about that?
Just real quick. Generally, it was a jogging class, and the instructor had the students run a 5K around campus, and it was extremely hot. And not think about, the potential heat injury. And then a lot of things, the first aid wasn't there. The emergency procedures weren't in place. There were a lot of things that went wrong in that case. And then what was kind of interesting after that case occurred, this was in California. They brought in Doug Casa from the Corey Springer Institute. He's done a lot of work with heat injury prevention, and they came up with a lot of standards and guidelines for all of the universities to follow to help prevent anything like that from happening again in their, jogging or other classes, that the university provides. So anyway, it's what I call kind of a reactive, aspect. If they would have been proactive and this instructor had been well trained and educated, maybe this heat injury wouldn't have occurred if that instructor had been, had the proper knowledge and skills and, was instructing the students in a safe and effective way. And then there's been other cases, there was just some recently, 11 million, another one was 13 million. I mean, it seems to me as I reviewed these cases over the last few decades that we're starting to see more and more of these cases in the millions of dollars. And so anyway, those are the, the damages that, the plaintiffs are seeking. And of course, the jury makes a decision and like I said, I think last time, most of these negligence cases are settled out of court. About 95% of them are. And so sometimes we know what that settlement amount is, but a lot of times we don't because it's not disclosed. It's not public information. But anyway, it's just kind of a trend that I've seen over the years where the damages seem to be getting higher and higher. And of course, gym owners and managers definitely want to make sure that their liability insurance, has enough, the coverage amounts are going to be adequate. And of course, they need to discuss those things with their lawyer and their insurance provider and so on. What kind of coverage and the amount of coverage they really need to have if they're ever liable, for the negligence.
That seems kind of excessive, though. I mean, me personally, I think like $40 million for heat stroke. But I mean, it must have been very intense, but you would think it would be worth it to spend the money versus settling at $40 million to be proactive, because all of these, even $14.5 million, I mean, those are excessive amounts in settlement, I think, for what the stroke, I understand, but a heat stroke injury outside in California. And California has pretty nice weather all year round. So I don't know. That's kind of
on a particular day, it was pretty hot. So, and again, you have beginners and, novices, and, if they're not used to the heat, acclimatized to the heat. I mean, you've got all kinds of, factors that are in play there. But this particular student had severe permanent damages and 24/7 care for the rest of her life. So from what I remember from the case, but, so anyway, kind of going back to these elements that the plaintiff has to prove: the duty, the breach of duty, causation, and the harm or injury. It's really important to understand that the breach of duty has to be the cause of the injury. And remember, I think last time we talked about all the different causes of injury, might be, all kinds of things that can, cause an injury. But in a negligence lawsuit, that plaintiff has to show that it was a breach of duty that caused the injury. So sometimes there are cases filed and the plaintiff has a hard time proving that it was the cause of the injury. And the injury might have been caused by something else. And so when we talk about, breach of duty and the importance of trainers and instructors, to have adequate knowledge and skills, in training and teaching their participants and clients, I think it's really important for people to understand that importance of practical skills, because the court might acknowledge the credentials of the trainer. They have a degree or certification or whatever it might be. But the court really doesn't care too much about the credentials. Okay. They might indicate it or mention it in their opinions. But what they're looking at is the action or the conduct of the professional. All right. So was the breach of duty is some kind of conduct or behavior. And that all is connected back to their level of skills that they have. So do they have the skill to design and deliver a proper exercise program given the individual's health and fitness status? Do they have that knowledge and skill to do that? And so I think when we think about certifications, and I know you just had a podcast, describing some of these certifications and so on. And, one of the things about accredited certifications, and, most organizations now have their certifications accredited through the NCCA, the National Commission on Certifying Agencies. And of course, to have your certification exam accredited, you have to meet all the standards of the NCCA. Now, what's interesting, and I think it's important for gym managers and owners to know, is that none of those standards require that the individual has had to have any kind of formal education or practical training prior to sitting for that certification exam. So when you look at all these certifications for trainers and instructors, really the only requirements are they have to have a high school diploma, AED CPR certification, and be 18 years old. And then they're eligible to take the exam. And so that's one of I think, the concerns for managers and owners is not to assume that because somebody has an accredited certification. Now, if I was a manager owner, that would be a baseline for me. Everybody would need to have an accredited certification. But then when they come in and I'm going to interview them, I'm going to test their knowledge and skills and, try to assess their level of knowledge and skills the best I can. And then probably, I think, like I mentioned last time, would be to offer some, formal education and practical training and maybe have them work kind of like a student teacher or an intern for a while under one of my really competent professionals, and then assess their skills, before they start working with, with clients and with participants. I want to be sure, because I know one of my duties is to make sure that my instructors, are well prepared and well trained, to perform the job, so they are, properly designing a program for the individual.